Alrighty, we're going to get started with our inaugural First Fridays with OFO information session. We're so fortunate to have EEOC attorney Elyssa Santos Abrams presenting today on of cases of interest to you. Before we get started, I just want to send out a reminder that National Course Registration opens up the second week of March and that Excel is the week of July 10th. I'm going to turn it over to Elyssa and look forward to a fun and exciting session.
Hello, everybody. When Lisa asked me to do this, well, first of all, this is our very first one. I kind of came up with these cases assuming that this wasn't all going to be OFO people, so we'll do it pretty relaxed because I know all of you. But she asked me, because of everything that's been in the news, to do sexual harassment cases. I thought, okay, fine, great. That should not be a problem. Only it is a problem, because as I went through all of the digests and our weekly emails that we get from Carlton with interesting cases, I discovered that we have almost no recent sexual harassment findings. I was able to get like 3 of them, and this is one going back into 2016. I've got some theories as to why. I'm sure you guys have theories as to why as well. But that's the situation. Despite this being a huge news story and there being a huge focus, within the commission on this topic, we are not making findings. Perhaps it's because agencies' internal procedures are working. Maybe it's because these don't get to the appellate level because agencies are afraid of the publicity that you get. I mean, did you all see the USDA, the article in the Post on the USDA? That's not something that agencies want to see. And from just going around talking to agencies, most agencies have a separate sexual harassment policy, separate and distinct from the one just on harassment. And, given what's gone on with EPA, we can name a whole host of agencies, they don't want to see this. So it's possible that they're just settling these cases. I don't know. But the reality is that I just did not find very many to discuss. So what I do have, we're going to go through first. I'm going to paste here, let's see if this works. Oh, yeah, I have one racial harassment case as well to discuss. Anupa just asked the question. Okay, so hopefully that works. Oh, yes, look. Okay, so that's the first case we're going to talk about. Heidi B versus FEMA. And in this case, she was deployed in a disaster area, and her first line supervisor was a unit leader. At least that was the description of his title in the case. Now, one of the issues with this case is trying to determine whether or not he was actually a supervisor. Uh-oh. Can everybody else hear me?
Yes, I can hear you.
Okay, I'm not sure Paula is having a little problem with her mic. One of the issues here is whether or not this unit leader was actually considered a supervisor, so we're going to get into that in a minute. But basically, what happened was she alleged harassment, sexual harassment and reprisal, and requested a hearing before an AJ. A hearing was held, and the AJ issued a decision finding that the agency was liable for sexual harassment and for reprisal discrimination. And the background is that complainant was working with this unit leader, what did they call him? Unit leader, who she claimed was her first line supervisor. And they were sitting together in the same office. She was approximately like 3 feet away from him. You know how those those cluster offices are. I think it probably looked like that, where there, were several people in one office and they had little cubicles set up. Anyway, she was working on a laptop, and he insisted on getting her a larger computer monitor and set that up for her and told her that she should go into the share drive and familiarize herself with everything that was on the share drive. When she opened the share drive, she discovered a full frontal nude color photo of this unit head in a Santa hat and holding a candy cane next to his genitals. She clearly complained about this incident to a former first-line supervisor, but not her second-line supervisor, because she knew that the second-line supervisor and the guy who was in the picture naked were friends and socialized outside of work. There's a lot of drama going on over here. Oh, we're having problems with the chat. Okay. So after learning about the incident, the second line supervisor had a meeting that lasted for 10 minutes with the unit head, the guy who was naked in the picture, and moved him to a separate office. Although the second line supervisor identified the meeting as a counseling session in the investigation, there was no written record of the meeting. And although the unit head was moved outside of her office, he still stayed in her work area. So, and additionally, the second line supervisor never reported this incident to anybody above him. So when the third line supervisor eventually learned about this incident, he sent the unit head home immediately and was told to work from home until further notice. They did an investigation. And what I found interesting about this investigation was, firstly, the second line supervisor told the complainant that the nude photo could be misconstrued and that if she couldn't do her job, she should let him know and management would release her from her assignments. So that sounds sketchy to begin with. And then after investigating the incident, the agency did terminate the unit head, but not for sexual harassment, but for violating information technology policies. Later on that year, they included a picture of him in a tribute for individuals who work for the agency. And although the agency's sexual harassment policy stated that management should immediately contact HR after receiving allegations of sexual harassment and to ensure that a proper investigation was done, management didn't do that. So based on the above, the AJ found the complainant was subjected to unwelcome conduct by the unit head, and that it was sufficiently severe to create a hostile work environment. And the AGA also imputed liability to the agency, saying that it was supervisory harassment that didn't result in a tangible employment action. Specifically, the AJ said that the agency was vicariously liable for this unit head's actions because it didn't prove both prongs of the affirmative defense that hopefully we all know. It didn't exercise reasonable care to correct and prevent and correct harassing behavior, and complainant did not unreasonably fail to take advantage of any opportunities to avoid harm. So moving on to the retaliation claim, what complainant alleged was that after this whole thing went down with the unit head in the naked picture, she tried to get a job at another location, but the second line supervisor who had asked her if she was unable to continue with her duties or that she misconstrued this naked picture, he withheld a performance evaluation. Additionally, on an ongoing daily basis for about 5 months, he engaged in what she considered petty criticisms of her work, singled her out, and falsely criticized her performance to other management officials. So based on all of that, AJ also found the complainant was subjected to reprisal discrimination. On appeal, the agency contended that the AJ did not properly apply Vance and Nassar in the finding of sexual harassment. Firstly, the agency said that the unit head didn't meet the definition of supervisor under Vance, and therefore, if it was considered coworker rather than supervisor harassment, the agency wasn't liable for the conduct because it took immediate and appropriate corrective action. Specifically, the agency said that on the day the incident occurred, they moved him out of the office that he shared with her, met with him, removed the nude photo from the shared drive so nobody else could view it, sent him home, and then he never returned to the agency. And regarding the reprisal claim, the agency argued that complainant didn't establish the but-for standard that the Supreme Court set up in Nassar. On appeal, this is what we found. First of all, we said that even if the unit head didn't meet the definition of supervisor under Vance and was considered a coworker, the agency was still liable because management knew about this unit head's conduct, but did not take immediate and appropriate corrective action. We found that agency took some remedial measures to stop the harassment, but didn't take any remedial measures to correct its effects on complainant or ensure that similar harassment by another employee didn't take place. We note that even though the agency asserted that it promptly informed staff about the firing of this individual and that headquarters was addressing the situation, it was absent any reference to sexual harassment, because if you remember, he was let go because he violated some kind of information technology rules, and there was no finding on sexual harassment made with respect to his removal. And we found that on appeal, the agency did not demonstrate that the AJ's findings were not supported by substantial evidence in the record. Based on everything in the record, we said that there was still enough evidence to impute liability for sexual harassment to the agency, even if he was considered a coworker and not the supervisor. Secondly, with respect to the retaliation claim, we said that we've already established in our case law that Nassar does not apply to the federal government, and that the but-for standard in Nassar is not relevant here. The AJ found that the management officials retaliated against her, and that is, substantial evidence in the record. So based on everything, we affirmed the AJ's finding of sexual harassment and retaliation. We ordered that her performance evaluation be raised to outstanding, compensatory damages of $50,000, attorney's fees, training, discipline, all of that good stuff. Do we have any questions on that case? Nope.
I have a question.
Yeah, sure.
And so I'm not wholly familiar with the harassment case law. But could the agency have argued that that they went with the IT policy because that would have led to an immediate termination, and so versus if it was going through the EEO process?
It's possible. I haven't looked at the whole case file, and it's possible they argued that, but our finding wasn't just based on that. It was also the fact that they moved him out of her office, but he was still in the same workplace with her for a while before they actually sent him home. So, it's fine to move him, but he has to be out of contact with her, which he wasn't. And there were several other things that they did by not following their own policy with respect to informing their particular office as set up in their policy that it should be an immediate referral. They didn't do that either. So there were several things that they failed to do in following their own policy, as well as taking prompt, immediate corrective action, which they didn't do. So we said, all of that taken together means that even if we looked at him as a coworker, it still would be, the agency would still be liable because they didn't take prompt and appropriate. Does that make sense?
Yes, it does. Thank you.
Okay, you're very welcome. Okay, so the next case we have, is Cathy M. versus Department of Agriculture. This case I thought was interesting, even though it's older, is because it goes to our argument that it doesn't matter what the sex of the individuals involved in is, it matters what the conduct is. So here, this is actually two women involved in this case. The complainant was working as a district wildlife biologist, and she claimed that for quite a while, actually, over a year, her first line supervisor, who was also female, was always flirting with her, required her to drive to various locations alone with her in the car, would steer the conversation towards sexual preferences and sexual conduct, tried to get her to stay on out-of-town trips in the same hotel with her alone. Complainant said that she was unwilling to do that, and she was very uncomfortable with the jokes and the comments that the supervisor made. And the record did also contain statements from coworkers saying that they'd witnessed the supervisor making sexual comments which, you know, were inappropriate in the workplace. Complainant also felt that once she made it clear that she was not interested in a sexual relationship with her supervisor, the supervisor demeaned and belittled her in front of coworkers, didn't treat her professionally, she was a target of constant put-downs, insults, and nasty comments, that the supervisor gave her performance evaluations that lasted in excess of 2 hours. I can't imagine what they were talking about. And she asserted that during these evaluations, the supervisor would criticize her for really minor infractions. He would slam the file cabinet shut, venting about all different things and different employees, complaining about various offices. And even though she received fully successful ratings, she left these sessions, you know, very disheartened because, I mean, who wouldn't? So about a year and a half after this began, she left the supervision of S1 and accepted a position at a different location. Shortly after accepting this position, she became aware that the former supervisor who had engaged in this sexual harassment had given her less than positive references when she had applied for various positions. And one of the things she said was, in these evaluations, that complainant had a lack of ability to accept criticism and tolerate others, and that there were various other negative statements that were made. So once she found out about these references, she went to EEO, filed a complaint, and the 3 claims that matter in our discussion here are, firstly, that the supervisor made unwelcome sexual advances and sexually suggestive remarks, and that the supervisor retaliated against her for rejecting these advances by bullying and denigrating her and subjecting her work to heightened scrutiny. And then in the following year, she learned that she'd been given a negative job reference. She asked for a hearing before an AJ, and over complainant's objections, the AJ issued a decision without a hearing in the agency's favor. The AJ initially dismissed both of the sexual harassment claims, saying that they were untimely. The AJ said that these were discrete claims, separate and apart from the timely raised retaliation part, the negative job reference, and therefore they were discrete issues and could not be part of a timely harassment claim. Further, the AJ said that even if claims 1 and 2, the sexual harassment claims, were timely raised, she didn't establish disparate treatment or hostile work environment. The AJ found that the supervisor's comments were not of a sexual nature or related to complainant's gender, and the agency subsequently adopted the AJ's finding of no discrimination. So when we looked at it on appeal, we said that the AJ the decision without a hearing was inappropriate because the record wasn't sufficiently developed and there were genuine issues of material fact and credibility of witnesses at issue. Initially, we said the AJ erred in finding that the dismissed claims, the sexual harassment claims, were discrete acts and were not part of the same unlawful employment practice because they were linked. We said that these involved the same supervisor, the same facility, and basically what complainant is saying is that she was subjected to sexual harassment. When she rebuffed the supervisor's attempt to have a relationship with her, she was then subjected to the retaliation that the AJ said was timely. So these are all part of the same claim, and we said they should be remanded for further processing. When we look at the hostile work environment, the sexual harassment, we also said that the AJ inappropriately analyzes as disparate treatment when this was all really a hostile work environment harassment claim. And we found that the AJ erred as a matter of law in concluding that there was insufficient evidence that the comments were of a sexual nature. In fact, we found that if the complainant's allegations were true, it's clear that this was unwelcome sexual comments and conduct related to complainant's sex. Complainant alleged that the supervisor inquired into her sexual preferences, made sexual advances towards her, and that after she made it clear that she was not interested, the supervisor began to treat her negatively, subjecting her to a hostile work environment. And we also found that the AJ erred as a matter of law in finding that the negative job references, I left this part out. The AJ found that the negative job references did not constitute a tangible employment action. We found that the record needed to be more developed as to this. We noted that the record did not contain a copy of these job references that were discussed in the file. And basically what we said was the AJ relied exclusively on the agency's portrayal of the facts and essentially failed to credit complainant's version. There are too many unresolved issues which required assessment of the credibility of not only the supervisor and the coworkers but complainant, and also supplementation of the record with respect to these alleged negative job references. So we sent the entire thing back for a hearing. Are we good on that one? Okay, and here is
Elyssa.
Yes.
This is Paula. I'm so glad I'm working now.
Hi.
I was just curious that since one of the allegations of sexual misconduct was that the supervisor inquired about the sexual preference of the complainant, I was just curious whether there was a sexual orientation issue raised here. Or whether
no, it doesn't look like in the file that she ever raised sexual orientation. She just did it as a straight up sexual harassment complaint. I don't think it would change the analysis at all, but yeah, specifically, there's nothing in here in this decision as written that makes mention of sexual orientation.
Okay, great. Thank you.
You're very welcome. Okay, so the next case we have is, this is actually an older case, but I've been using it for a while because I find it pretty fascinating in that it's sex-based harassment. It's not a sexual harassment complaint. But the conduct is interesting in that what the agency basically argued was that the management officials treated everybody terribly, so it wasn't actually sex-based harassment. So basically, this woman was working as a trial attorney in the U.S. Embassy in Baghdad. And apparently there were 4 male management officials that were supervisors for the entire office, that were various attorneys and executive officers that were, it looks like the working environment was egregiously bad. They didn't treat staff in a favorable way. Testimony from a number of employees affirmed like extreme mistreatment, but specifically more extreme mistreatment of female employees. There were 9 different employees that provided affidavit testimony that all substantiated this basic, working environment. But the specifics of complainant's claim were that she was subjected to sex-based hostile work environment when numerous assignments were taken away from her, numerous witnesses, that she was treated harshly and disrespectfully, that this was persistent and continual. When she raised the issue of sex discrimination to management on numerous occasions, no steps were taken to correct or discipline the management officials that were engaged in this discrimination, and that she was eventually subjected to retaliation as well when she asked for an extension of her detail. The agency, in response, argued that management treated all staff poorly and not just women, which, when we do harassment training for agencies, like we kind of make a joke about that, management officials say, well, do I have to be nice to everyone? No, you don't have to be nice to everyone. But to actually see an agency use that as a defense, that we treated everyone that worked for us so terribly that this wasn't a sex harassment situation is unique to me. I have not seen that before. They also said that management didn't realize that this was a gender discrimination complaint, and even if her claims were taken as true, they weren't severe or pervasive enough to create a hostile work environment. What we found was that that was not the case at all. We found that indeed there were situations where, the management officials treated male employees badly. The testimony of coworkers, which there were quite a few, made it clear that there was overwhelming evidence to establish that female staff members were subjected to greater and more targeted mistreatment. Basically, what management did was they would disparage women when they were out of the office by complaining about their work skills, imitating their voices, and exaggerating their mannerisms in speech. They raised their voices to female employees on a frequent basis. where complainant was a particular object of this behavior. They would mock complainant by repeating her words in a high-pitched voice before yelling at her. They were very harsh in the words that they used. When another employee had complained of sexual harassment, one of the management officials took the email around to all the other staff members, showed it to them, thereby revealing her identity, and pretty much made fun of her for complaining about the sexual harassment in the first place. So the women were routinely ignored, dismissed, patronized, and this harassment was ignored by management. There's clear evidence also that management officials took work away from female staff members and gave it to the male employees. And would yell at the women and say, "I don't even know what you're doing here. Why do you work here?" etc. So what we found was that taken together, these instances of this conduct was pervasive enough to create a hostile work environment based on sex. And there was a basis for imputing liability to the agency because these were management officials that were doing it, and they were empowered to take tangible employment actions against complainants, such as removing her work and not extending her details. We also found that there was reprisal in that they didn't extend her detail. They interfered with her application process for extending her detail after she had complained to EEO about the sex harassment. So here we imputed liability to the agency for both sex harassment and reprisal, and it was remanded for the usual, for finding of compensatory damages, discipline, training, etc. Any questions about that one? I think we're running out of time here. I thought this was going to take less time. One more.
You can take
one more
case
that's a little bit older.
You can take additional time if you'd like, Elyssa. We're not going to.
Okay, yeah, there's one more case that's a little bit older, but I found it this morning actually, and I thought it was really interesting. This is the Blanca B versus Department of State. Here, she was, it's a very complicated procedural history that isn't relevant at this point, but basically what she was alleging was that she was subjected to a hostile work environment, including sexual comments and unwelcome touching. And when we look at the background, let's skim down here, what I found most interesting about this case was that the agency argued that the sexual harassment didn't occur because the alleged harasser denied everything and provided quite a few character witnesses and statements from coworkers saying he would never do this kind of thing, he's an upstanding guy, et cetera, et cetera. However, when we looked at it, we said that, when we look at sexual harassment cases, we have to rely on the determinations of credibility of the parties. Most of the time when you're dealing with sexual harassment, there aren't going to be witnesses. So what we say is a victim's account has to be sufficiently detailed and internally consistent to be plausible. Anybody who complainant discussed the incidents with, such as coworkers, that also goes to establishing credibility. And evidence that other employees were harassed by the same person is also quite persuasive. And all three of those were a factor in this particular case. Here we found the complainant's account was detailed and internally consistent. It contained detailed descriptions of incidents and dates. Basically, that her second level supervisor's harassment started off with jokes as statements and things that were supposed to be construed as jokes in case they were, rebuffed. And then he went on to inviting her out to dinner. Things escalated when he started asking intrusive questions about her sexual activity that were designed to uncover how she thought about sex and, having an affair with him. Then that escalated to touching. He kissed her on the forehead, pinched her cheeks, progressed even further when he touched her butt, etc. And then it finally escalated to him actually taking her hand and trying to get her to touch him, in his private parts. So basically, this was an account of a plausible escalation of sexual harassment over time. Additionally, while we acknowledge that he had strong denials of everything that she stated, and there were powerful character references, what tipped the balance in the complainant's favor was that another coworker also complained that she was a victim of this second-level supervisor's harassment in ways that were very similar to complainant. And there was a statement of another individual corroborating that they had overheard this second-level supervisor tell sexual jokes. We found the complainant was, in fact, subjected to sexual harassment, and we found that it was sufficiently severe and pervasive, that it went over a long period of time, and a reasonable person under the same circumstances would have viewed the work environment as hostile, offensive, or abusive. So what we did was order the agency to conduct training, take disciplinary action against the supervisor, look into compensatory damages, and all the rest. I just found that case particularly interesting because it was very clear about how we analyze credibility when there isn't an AJ involved, when it's a final agency decision in these harassment type cases, which seems to come up quite a bit when we look at harassment, and there are no witnesses. Do we have any questions on that case? Okay, so looks like we are about out of time. Let's very quickly do this racial harassment case because Anupa did ask a question about it, and it's pretty interesting. This is the last one we have for today. This gentleman working for the Department of Defense was a materials handler in a facility in Japan. And what he alleged, I'm not going to read this because it's that offensive, was that the work lead would shout extremely offensive racial comments at him, including repeated use of the N-word. And that when he reported the remarks to his second-level supervisor, it went through a formal investigation, and there was eventually this employee was relocated to another location 40 miles away and suspended for 10 days without pay. However, in the interim, while this investigation was going on, this employee was posting additional comments on social media using very aggressive, threatening language. And one time after he was transferred, approached complainant in his car and again made some threatening remarks. So complainant filed an EEO complaint of racial harassment and requested a hearing. Over complainant's objections, the AJ granted a motion for summary judgment, finding that there were no material issues of material fact. And what the AJ concluded was, although this racial harassment did occur, the agency took immediate and appropriate corrective action. In response, complainant said no. In fact, the coworker continued to make racial remarks until the transfer, which didn't take place immediately. And that the AJ, although the AJ determined that there were no additional remarks made, there was no investigation into it. So basically, the AJ just adopted what the agency's argument was, the argument being we did everything we were supposed to do, despite complainant saying, no, in fact, you didn't. And complainant maintained that this coworker continued to make racist comments on a daily basis, even after he reported it until the time that the coworker was transferred. So what we found was that the AJ erred in concluding that there are no genuine issues of material fact in this case, and the AJ accepted the agency's assertions regarding the corrective actions taken by the agency in their entirety, notwithstanding the fact that complainant argued that the corrective actions were not taken. For example, the current record is not clear as to whether these racial comments continued after the agency began its investigation or not. And unless we have that information, we can't determine liability. So we vacated the agency's final order and remanded it for a hearing. And we specifically stated the hearing needs to focus on whether the agency can prove by a preponderance of the evidence that it took prompt and appropriate corrective action in response to complainant's allegations of a hostile work environment. The reason I thought this case was particularly interesting is because I do see this come up quite a bit, where agencies will say, yes, we did everything we were supposed to do, and we did it promptly and appropriately. And there's this assumption that if they're saying it, it must be true. And what we say in this case is, no, we need more. We need actual evidence in the record to show exactly what the agency did make sure that it was in fact prompt and appropriate if an agency wants to avoid liability for harassment. So that is what I have for you guys today. Hopefully that was interesting and useful. Do we have any questions before we end it? I'm not hearing anybody. Hopefully you're still all there and haven't been blown away.
Good job, Elyssa.
Very good job. Elyssa, we really appreciate you.
You're very welcome.
Really appreciate you presenting for our inaugural First Fridays with OFO. And we look forward to everyone joining us again the first Friday of every month. What I would suggest to everyone is if you would, please follow us on Twitter at EEOC Fed E News, and feel free to forward any topic suggestions that you may have. As you know, we'll consider those, and we may even ask some other folks here in the office if they would be willing to present as well. So again, we really appreciate everyone for joining on this windy day, and look forward to seeing you again on another one of our First Fridays.
Lisa, I can't remember. Did we mention about the national course registration in Excel? I can't remember if you said it at the beginning.
Yeah, I did at the beginning, but we had some folks that weren't on, so I'll cover that again. The national course registration is going to be available online within the next 2 weeks. And also want to ask everyone to save the date for Excel, which will be July 10th through July 12th here in DC.
Excellent. Thank you so much, Lisa. Thank you, everybody.
Thanks, everyone, for attending.
Thank you. I'm trying to leave.